Legally Speaking with me, Tarun Nangia. Justice Pardiwala and Justice Pankaj Mittal judgment says execution proceedings must be completed within 6 months. Otherwise, the presiding officer will be answerable. Now, we're going to go into detail about the judgment, what it means, who has been made answerable, what will happen at the High Court level, all of this and more we will discuss today on the show. Let me welcome Senior Advocate Percival Bilimoria, Advocate Tahira Karanjawala, partner with Karanjawala and Company, Advocate Ruchi Agnihotri, who incidentally joins us from Gandhinagar today. Good to see all of you, and looking forward to some interesting insights on this issue. I'll go to Tahira Karanjawala for the opening comment. Over to you, Tahira.
Hi, good evening, Tarun. Thank you. So this important observation has been made by the Honorable Supreme Court with respect to the execution of, the delay in execution proceedings. And I think one has to appreciate the context in which these observations were made. In this particular case, there was a situation where certain defendants who had chosen not to sort of pursue the original suit then popped up in execution proceedings and claimed that there had been a fraud, that they were not aware of the execution, and claimed protection under a particular enactment, saying that they were in possession of land as cultivating tenants. So, and these proceedings had been going on for many years, and the executing court allowed this objection, which was confirmed by the High Court. And it is in this context that the Honorable Supreme Court observed that this was a collusive objection, in fact, because the two parties, who had popped up in execution proceedings were actually the nephews of the defendants who had been defending the suits, in the original proceedings. And therefore, he observed, the bench observes, that this was a collusive, vexatious, obstructionist objection which was raised in execution and should not have been entertained by the High Court. And it is in this context that these observations then came to be made by the Honorable Supreme Court that execution proceedings should not be allowed to continue beyond a period of 6 months. Actually, this observation had been made in 2021 by another bench of the Honorable Supreme Court, in which they had laid out a number of guidelines to be followed by courts while adjudicating execution proceedings. And one of the guidelines there was this, that if any executing court is taking more than 6 months to dispose of an execution petition, then it must record reasons for doing so. And the observations made by the Honorable Bench in this case are only, in a sense, a follow-up to that case, saying that the Honorable High Courts should call for data from the respective district judiciaries under their supervision, and should assess the progress made as far as following this guideline is concerned. And if these guidelines are not being followed, then the concerned officer should be made answerable. And this sort of, the object is to streamline execution proceedings so that litigants who have already spent many years and have a decrease in their favor are now not subjected to a retrial where where the execution courts get into the merits of the matter again and start adjudicating the entire process again. So it is in this context that these observations have been made, and I think that they, it is important for the higher judiciary to sort of, make these observations from time to time, so that appropriate guidance is given to all the courts, under their supervision. And it gives a sort of framework to each of the district courts as well. And at some conscious or subconscious level, then, courts are not likely to simply adjourn execution proceedings. And I mean, there may be an exceptional case in which there is, reason for the 6-month period not to be adhered to, but then specific reasons have to be recorded. So this itself serves as a sort of a framework, which is, I think, what the Honorable Supreme Court intended.
Thank you. Thank you for that opening comment. I'll go to Advocate Ruchi Agnihotri for her comment.
Thank you for having me on the show, Tarun. To start, it's, a very innocuous judgment on the face of it. There are multiple thousands of such matters which are pending in courts across the country at all tiers and hierarchies of our judicial system. two people enter into an agreement to sell with another bunch of two people, an amount is paid, then an execution is sought because the other party fails to perform the agreement to sell, and the other parties then use various modes and mechanisms which are legally available to them. For example, put in two people and saying these people are actually in possession, they cannot be dispossessed, etc., etc., etc. The facts are really not that relevant in this particular case, in the sense that those are they're relevant to the litigants, of course, but they're not relevant because it's the sad story of many, many litigants across the country. What is quite amazing in this judgment is that a very innocuous bunch of facts has been picked up by Justice Pardiwala in this judgment. It's a judgment which actually just gives a direction and asks the courts to collect data, the high courts to collect data from the district judges and issue directions and exercise supervisory jurisdiction. But look at the heart and spirit of the judgment. The heart and the spirit of the judgment is actually summarized in the quotation of the Srinath versus Rajesh judgment of 1998, which Justice Pardiwala starts this judgment, where he's actually summarized, while quoting that judgment, the woes of the litigant. The arduous process that a litigant goes through in first getting a decree. The multiple tiers and levels of appeals and revisions, etc. In this case, the matter went right up to the Supreme Court in a review petition, even in the original proceedings. Only then he got a decree. The agreement to sell was 1980. The decree comes in his hands in 2004. And we are in 2025. If we can see the cause title, the original person is dead. And the legal heirs are prosecuting this matter. So the remedy becomes the curse, actually. You put your money and then you expect that I can reinforce this at a later stage, and everything is in your favor and you get everything. You get all the orders that you can. And yet today, you are dead and your legal heirs are still trying to get that property out simply because the other side just put two people in possession and said, now they can't be dispossessed because they are not title holders. And various mechanisms were used. So to that extent, it's a fascinating judgment. And, Justice Pardiwala has a history. I was just reading up about him in the sense that, he has apparently cleared 1,200 matters while he was a judge of the Gujarat High Court in just 11 years that he was there. And he wrote 1,807 judgments. And, the kind of judgments that he has passed while he was a judge of the Gujarat High Court give us a sense of where we are headed when he's going to be, heading the apex court of the country for 2 years, 3 months. Because in COVID-19, for Rath Yatra in Ahmedabad to take place, because it would spread the infection. And Justice Pardiwala, on the other hand, asked for intervention positively in favor of migrant workers because COVID-19 was preventing them from getting food relief and medicinal aid and being allowed to go to their hometowns. So this judgment actually shows that, again, it's taking a procedure. It's saying that procedure is the handmaiden of justice. Please do not use procedure to defeat the ends of justice. And that seems to be the running thread coming from the Supreme Court of India. And Justice Pardiwala has just reinforced it today with the directions that he has given.
Thank you. Thank you for that opening comment. I'll go to Senior Advocate Percival Bilimoria. Can you take us through this whole issue as far as the law point is concerned? Also, what happens in various cases? Also, what is your view and what can be done? And also what Justice Pardiwala has said with a few examples, if possible. Over to you.
Yeah. So I think in a way, as Tahira mentioned, there have been a couple of other judgments as well, where the 2-year time limit was set out before. I think what is different here is that the Supreme Court has now said that, well, the presiding officers will be held responsible. In fact, it has called upon the high courts to, on the administrative side, to check what is the status of all the execution cases. So I think the practical effect of this ought to be felt, far and wide. The law on execution, unfortunately, it's a reality. See, execution is Order 21. Okay, it has 106 rules in the CPC. And it's often said that it is a self-contained code. So just Order 21 itself is like a statute, a separate statute. Self-contained means you don't have to look anywhere else. You only look at Order 21, it provides for everything, cost, etc. Now, the other thumb rule that one always goes by is that one doesn't go behind the decree. What does this mean? It means that when you get a decree from the court, matter should end. That should be the finality of the issue. You don't start, the execution court cannot start asking reasons or sitting in judgment over the decree. Absolutely not. However, the execution court can construe. So there are certain other decision, a line of decision which says where the judgment is not clear, and it often happens, the judgment may have language which both the parties may interpret differently. Now, what does the execution court got to do? So the execution court can construe what it means. Now, in the process of that interpretation of the decree, it will not substitute its own view as to what it means. They'll have to go into the pleadings that look during the suit, this is what was put forward by each party. These were the decisions that were put forward, and then the execution court will say this is exactly the correct meaning of what the decree says. Then the other complication is we have section 47 of the CPC. So section 47 was clearly interpreted in Rahul Shah, which is a 21 decision that Tahira mentioned. And Rahul Shah clearly states, and Justice Partiwala depends on Rahul Shah also, because that provision, I don't recall the exact number of the provision, but essentially what it said is that the sum and substance of section 47 is that any issue that is put forward before the adjudicating court cannot be re-agitated. And even if there is some issue that was not argued before you cannot now argue in the execution proceeding. So I think the jurisprudence is very clear, and unfortunately, we still have a situation where, despite very clear jurisprudence, the execution proceedings take time. And I think this judgment tries to remedy a lot of that.
One thing about the action that will be taken if this is not done, anything there, will any action the court take if these things are not done as now the court has directed to be done?
Well, it says that the presiding officer will be held accountable.
No, what does that mean?
I don't know. I mean, I guess they will be. See, the high courts have supervisory jurisdiction over the district courts. So, I mean, if they call for records and on the administrative side, if they find that decisions are pending for much more than 6 months, especially execution proceedings, I think ultimately the sum and substance is that this judgment should light a fire under the presiding officer's feet.
So do you think this is like a
galvanize them into deciding quickly?
Is this a warning from the Supreme Court?
I think, see, there's been a lot of public angst about this. Tarun, we have discussed this on many occasions. It's not just suits, but, execution of awards which have attained finality. I'm not talking about challenge to the award. That's a whole different line of argument altogether. You can challenge an award. You have every right to challenge an award as long as the statutory conditions in Section 34 of the Arbitration Act are met. But once the challenge is over and you are in execution proceedings, why should it take so long? And frankly, I don't know why. I think it's simply a question of, the inadequacy of the number of judges, etc. I mean, see, if there's a hearing and the matter is deferred for any reason, somebody takes an adjournment or something, or sometimes matters don't reach. Then the next date is about 3 to 4 months later. And that's because the courts are overburdened at this point of time. And see, ultimately, this is a great decision, but I really believe that, to solve this problem, we need to ensure that our judiciary's numbers are strengthened.
Okay, so basically that also is a problem, that we need more judges, which is of course true. We'll take this now to Tahira Karanjawala for her comment.
Thank you, Tarun. So I think, as Percival sir was saying, that the objective of this observation is, I mean, I'm not sure whether it's to light a fire, but it's certainly to try and streamline judicial efficiency. This will also serve to reduce pendency if there is a quick, disposal, and also the litigants will be able to get speedier justice. So I think that it's not so much a warning as an attempt by the Honorable Supreme Court to streamline the process. And as Sir was rightly saying, that the entire premise is that the executing court cannot go into questions of merit again. It cannot go behind the decree. So I think this is the underlying principle which is sought to be reinforced by all these judgments, which make these observations, so that, frivolous, vexatious objections simply at the stage of execution are not entertained by the courts in a light-fashioned manner. And as long as that principle is followed, there is no reason why 6 months is not adequate for a court to be able to dispose of an execution petition where all the decisions on merits have really been already decided. And I mean, what is you were saying that, what will be the consequence of if this is not?
Yes.
I mean, at some level, yes, there is some sort of administrative pressure on the courts to then adhere to these timelines. Of course, these things are not set in stone, and even these judgments say that this is in the nature of guidance, and direction to the court. So I don't think there'll be any penalties as such, but it will provide a basic framework, and that often helps to just regularize the process and prevent abuse of the various provisions of the CPC, which can be used to be vexatious and or be obstructive. So I think it's just to counterbalance that.
Point very well taken. Let me take a very simple aspect, like a landlord-tenant dispute. Execution takes sometimes forever. It is a small thing, but it's so common in India. A landlord-tenant, this is misused. Many times it's impossible to get a tenant evicted. Mostly if he's connected and powerful, it is almost impossible. Of course, law is used as a weapon in this. Ruchi, can you comment on that?
Yes, so I'll first answer a previous question of yours. Just like in the bureaucratic hierarchy, the lower courts and the subordinate judiciary is subject to supervision by the high courts of a state. Right? So when you say you're accountable or answerable on the administrative side, yes, it cannot, you cannot remove them from office, but definitely it will affect their promotions, and it will affect their, there can be many other things, because the High Court of a state can take action against lower court judges, which could be censures, which could be, negative comments in their annual confidential reports, etc. Because the lower judiciary in the country comes to office through an exam, just like a bureaucrat would, and is amenable to similar conditions of service, right? So it's not similar to a high court judge in that sense. And removal of office would not be possible, of course. But answerability by itself, or accountability, as has been mentioned by Justice Pardiwala in a Supreme Court judgment, which has supervisory jurisdiction over all the courts of the country, means a lot. It is a huge statement falling from the apex court of the country. and it's a message. Tarun, this judgment is trying to eliminate personal individual biases out of the picture. For example, I may be very efficient in my work, you may not be that efficient. If I know that I have to complete this within 6 months, or I may be answerable, then whether I am liable to be efficient or not, whether I will make that extra effort. So it is eliminating the individual I'm not being able to that word that I want to say, but the differences in the individuals holding office is getting eliminated, and a uniform system of is being put into place. There is now a time limit. What Rahul Shah's judgment did in 2021, which has been heavily relied upon by Justice Pardiwala in this judgment as well, is it explained the ambit of the court's powers, the executing court's powers under Section 47. It laid down very strict guidelines on what a decree should have, so that while executing, because the court has wide powers while executing a decree also, to pass orders in discharge and satisfaction of execution of that decree. So it laid down strict guidelines on how clear, concise, precise, etc. decree should be. I'm sure going forward, those things would be taken into consideration. But here we are dealing with a decree which is in 2004, right? When Rahul Shah's judgment has come in 2021. So the point is, executing courts, if their execution proceedings in this particular matter went on from 2004 till 2019. And the matter came before the Supreme Court in 2019, and 5 years, almost 6 years in the Supreme Court as well. So imagine. So that's what Justice Pardiwala is saying. 6 months, over and over.
You have highlighted a fair point. We'll take a 1 minute comment from Tahira, then we'll take the final comment from Senior Advocate Percival Billimorio. Tahira, in the case of landlord-tenant disputes, do you think this is a wide applicability? If courts become stricter on execution, at least a lot of harassment, many times the landlords would not face, or otherwise also. Over to you.
Yes, I definitely think, for specifically where it concerns, sort of possession of property, it's very difficult to compensate. At least with money, there's an interest component which runs if you don't make the payment. But if you're not able to get your property back for years, which is often the case, as Ruchi was pointing out in this particular case, the execution proceedings had taken 15 years. The execution proceedings had taken 15 years. So in these situations, especially with sort of any sort of handover of immovable property or vacation of premises by a tenant, having sort of time-bound execution proceedings will really help streamline the system and meet the ends of justice, which is, I think the effort of the Honorable Supreme Court in this case. Of course, it's not only confined to handover of immovable property. These observations are made, in respect of all types of cases. But I think specifically in those cases, it would help to serve the ends of justice.
Point well taken. I'll go to Senior Advocate Percival Billimoria for the final comment of the show. Over to you. Largely on the whole execution ecosystem in India, if you could make a commentary that if we could do this better, how will it instill confidence of the investor in the Indian market? Because as you see, I'll tell you a small example. A lot of NRIs who invest in India sometimes sort of fall prey to such disputes, and it's very difficult for them to come and litigate here. So, in a country like India, where you have a huge investing community, which are Indians who reside abroad, they don't want to get sort of, stuck in disputes. And when the courts are slow, then there is a problem. Do you think in such cases what Justice Pardiwala, Justice Pankaj Mittal did is important? Could you just give us a small comment?
See, it's very important, Tarun, and whatever phraseology you use, I think the crux of the matter is that the system needed to be galvanized, and I think this judgment does that. So the administrative ability of the high courts to kind of, just the fact that there are reports that are now being collated and going to the high courts should galvanize the system. The thing is that most execution petitions are filed in the district courts. Now, the district courts, I mean, I know, I can definitely tell you that in high courts or like Bombay, Delhi, for example, and many others, it doesn't last too long. But it is really the district courts that needed to be a little more, uh, aware of the fact that this is a suit that is long drawn out, and now we have a decree. Right? There is also a process for correction of a decree if there is an error. So that's a simple thing. I mean, it doesn't have to go through application and reply and rejoinder process that, there's nothing to prevent a judge from actually allowing an application and hearing a reply. But it can be disposed of very speedily. See, as far as landlord-tenant disputes are concerned, there's a little old hangover. I mean, there's this Pagri system in Bombay, so where I have my chamber, in that same building, there are chambers where the rent today is 300 rupees. Can you believe it? I mean, it's incredible. Okay, so in today's day and age, and but I mean, you can eviction is still not as difficult a process today as it was about 20 years ago. Right? You can even take the help of the law to evict tenants. So again, there is a little human element that has to be taken into account here. I think the major challenge in execution going forward is if it's a money decree, and the party doesn't have the money to pay. Right? Then what happens? Because you cannot squeeze water out of a stone. I think this is something where courts have given time, and I think you have to look at the individual situation of each of these, judgment debtors and then rule accordingly. But there is some human element that comes in here. You may have lost a case, but at the end of the day, if you don't have the money, then what happens? I think this is the only reason why, there may be some delay in future, hopefully.
Thank you for that comment. Indeed, an important judgment passed by Justice Pardiwala. In the end, the litigant who faces the brunt of delayed execution knows the frustrations that he has to go through in life. Supreme Court takes cognizance and issued such judgments is something that we must take up. Ruchi wants to come in, then we'll end very quickly, Ruchi.
Yeah, I just was saying this judgment reeks of empathy, and that is so nice and refreshing to see. When the judges and the court feels the pain of the litigants, I think half the battle is won.
I think two judgments with empathy by Justice Pardiwala. The last time was about blind, in a sense, candidates for judicial examination, which we did a show on, and now this. I would like to thank Senior Advocate Percival Bilimoria, Advocate Taira Karanjawala, Advocate Ruchi Agnihotri. You made time and you joined us on the show. Appreciate your joining us. Thank you so very much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.